What about you, sir? Do you think the colored students will show up?
If I got anything to do with it, they won't show up. Well, I think it's a breaking point of the school integration. I just don't feel that they have a right to go to school.
Since the 1896 Supreme Court ruling of Plessy v. Ferguson, which decided that separate but equal public services were constitutional, legalizing segregation in the U.S., many states in the South developed laws known as the Jim Crow laws that kept blacks and whites separate in all parts of life. It wasn't until the year 1954, when Linda Brown was refused entrance into Topeka, Kansas's white elementary schools, arguing that segregated schooling of whites and blacks was unconstitutional because it violated the 14th Amendment's guarantee of equal protection of the law, that segregation would be successfully challenged. In the decision of Brown v. Board of Education of Topeka, Chief Justice Earl Warren wrote that in the field of public education, the doctrine separate but equal has no place, as segregated schools are inherently unequal. Therefore, the plaintiffs were being deprived of the equal protection of the laws guaranteed by the 14th Amendment. This ruling officially stated that segregation was unconstitutional, but it did not clearly specify how schools were to be integrated, which prolonged the conflict between those that favored integration and those that didn't. It took the court a year to issue a second ruling, only to say that integration must be achieved with all deliberate speed, but still gave no clear course of action. Opposition to the Brown decision erupted in the South, and on March 12, 1956, a Southern manifesto titled the Declaration of Constitutional Principles was signed by 32 representatives and 19 senators of Congress, compromising more than one-fifth of the members of Congress and receiving support from all of the states that had composed the Confederacy. The manifesto argued that the Brown decision's use of judicial power trespassed on the states' rights. It urged Southerners to use all necessary means of confusion and chaos to prevent school integration. One of the most controversial and heated sites of school integration was Little Rock, Arkansas's Central High School. Known as one of the top-ranked high schools in the country, serving a very elite level of children, this all-white school attracted lots of attention due to its desegregation. Following the Brown decision, in May 1955, the Little Rock School Board officially announced that it would implement an integration policy that would achieve desegregation in 6 years, following a gradual shift. Developed by Virgil Blossom, the school superintendent, the plan was to begin integration in the fall of 1957, with a few blacks attending one school, Central High. Other schools would follow, but desegregation of junior high schools would not even begin until 1960, and grammar schools would be set last. The date for their integration was not even set by the plan. The Little Rock chapter of the NAACP watched with unease as time passed without any appearance of immediate intentions of action. Knowing that the school board's desire to delay integration was a violation of the Supreme Court's statement that integration must be achieved with all deliberate speed, the NAACP decided to file a lawsuit in order to expedite the process of integration. At the same time, in January 1956, many black families had been attempting to register their children for enrollment in white schools, but were turned away by school officials. 33 of these children went to the federal court for the Eastern District of Arkansas, claiming that the school officials were conspiring to prevent the integration of black children through postponement of plans to integrate. The plaintiffs, the first alphabetically John and his sister Thelma Aaron, represented by the NAACP, opposed the defendants, including William G. Cooper, the president of the Little Rock School District, and other school officials. These would become the Cooper and Aaron for the case. The first trial was held in August 1956, in which Judge John E. Miller ruled that the school board's actions were both prompt and reasonable. Even after appealing to the Eighth Circuit Court of Appeals, Judge Miller's ruling was affirmed that the school board's actions were constitutional. In the fall of 1957, 9 black students of perfect academic standing, known as the Little Rock Nine, were enrolled to attend Central High School at the start of the new school year. However, on September 2nd, Governor Faubus announced on television that because a majority of Arkansas voters opposed school integration, and because there is a threat of open conflict if these students went to the school with other white students, he would order the Arkansas National Guard to keep black students from entering Central High School.
I have therefore, in accordance with the solemn responsibilities and the oath of my office, taken the following action. Units of the National Guard have been and are now being mobilized with the mission to maintain or restore the peace and good order of this community. Advanced units are already on duty on the grounds of Central High School.
8 of the Little Rock Nine arrived together, but 15-year-old Elizabeth Eckford arrived alone on the other side of campus, surrounded by a hostile mob. In an interview later, she recounted,
I expected that I would go to school as before on the city bus. So I walked a few blocks to the bus stop, got on the bus, and rode to within 2 blocks of the school. Got off the bus, and I noticed along the street that there were many more cars than usual, and I remember hearing the murmur of a crowd. But when I got to the corner where the school was, I was reassured seeing these soldiers circling the school grounds. And I saw students going to school. I saw the guards break ranks as students approached the sidewalk so that they could pass through to get to school. And I approached the guard at the corner, as I had seen some other students do, and they closed ranks. So I thought, well, maybe I am not supposed to enter at this point. So I walked further down the line of guards to where there was another sidewalk, and I attempted to pass through there. But when I stepped up, they crossed rifles. And again, I said to myself, well, maybe I'm supposed to go down to where the main entrance is. So I walked toward the center of the street. And when I got to about the middle, and I approached the guard, he directed me across the street into the crowd. It was only then that I realized that they were barring me, that I wouldn't go to school.
Faubus continued to deny entrance to black students for 3 weeks, temporarily shutting down the school system. The school board followed these actions by suggesting that students not attend Central High School until the dilemma had been dealt with. On September 2nd, the court issued a preliminary injunction against the governor for exceeding his authority by obstructing the school board's plan for integration and opposing the Supreme Court decision in Brown v. Board, supported by Eisenhower's intervention by sending federal troops of the 101st Battalion who would escort the Little Rock Nine into the school, ensuring that they were allowed to attend.
That responsibility, I have today issued an executive order directing the use of troops under federal authority to aid in the execution of federal law at Little Rock, Arkansas.
The Army troops were replaced by federal guardsmen who remained for the rest of the year. As the end of the school year approached and integration had not at all progressed, the school board and the superintendent petitioned to postpone, once again, the desegregation process. Their reasoning was that the current plan attracted violence and conflict, which was detrimental to the learning environment at Central High. The school board requested for integration to be halted, the black students temporarily withdrawn, and their integration be resumed after 2.5 years. The district court under Judge Lemley granted their request. This time, the plaintiffs appealed directly to the Supreme Court. Chief Justice Earl Warren wrote in the decision, "As this case reaches us, it raises questions of the highest importance to the maintenance of our federal system of government. It necessarily involves a claim by the governor and legislature of a state that there is no duty on state officials to obey the federal court orders resting in this court's considered interpretation of the United States Constitution. We reject these contentions." The court therefore refused to sacrifice the constitutional rights of the plaintiffs to the violence and disorder which have followed upon the actions of the governor and legislature. pointing out that no state elected official can officially wage war against the Constitution without violating his or her oath to support it. Nor can state elected officials nullify children's rights indirectly through evasive schemes. The Supreme Court argued not only in support of school integration, but established judiciary supremacy of the federal courts over state courts that would be debated in future cases. The ruling of Cooper v. Aaron established the Supreme Court's interpretation of the Constitution as the supreme law of the land, basically giving the Supreme Court the official last say in court decisions. This could be applied to the South's nullification crisis in the 1930s over the federal tariffs of 1828 and 1832, and also the secession of the South following the election of Lincoln in 1860. In both of these situations, the states opposed the federal law. Cooper v. Aaron officially states that this is unconstitutional. However, the ruling is still debated today, and there are still many policies that contradict its verdict, especially in the issues around immigration policies. Certain cities known as sanctuary cities, such as Seattle, San Francisco, New York City, and LA, have intentionally ignored federal immigration policies by refusing to prosecute citizens with an immigration status or expired visas differently and limit their cooperation with the federal government to enforce immigration laws. Furthermore, medical marijuana was first legalized in California in 1996 by Proposition 215, which contradicted the previous prevalent federal law that specified marijuana as a contraband. 10 other states have legalized marijuana since then, such as Washington, even though federal law still stands as a contradiction to the legalization policies of the West. While Cooper v. Aaron only allowed a very limited amount of black students to integrate into Little Rock's school system, it added to a greater cultural environment of change and gave momentum to the rising civil rights movement. The Little Rock crisis occurred at the same time as Rosa Parks refused to give her seat up to one of the white passengers, which would spark the Montgomery bus boycott. In 1957, Martin Luther King formed the Southern Christian Leadership Conference and began a movement to combat segregation by intentionally sitting in racially restricted areas, deliberately inviting arrests to draw attention to the injustices of segregation. With the rising amount of television sets in America, which by 1961 was one set for every 3.3 Americans, news spread much faster and many people across the country were being exposed to the atrocities of segregation that were occurring in the South, which would initiate a period of cultural change towards racial equality.